laws. Anytime America police and immigration you will go home. Now, when you read potential expatriating acts, you say, "Dear bet me do a coffee and I make kaya Section 349 of the INA, that's 8 U.S.C. 1481. There's a document, the PDF there, as amended, states that U.S. nationals are subject to loss of nationality if they perform certain specifiedacts voluntarily with the intentions to relinquish U.S. nationality. Briefly stated, these acts include almost say we are U.S. citizen. Nyame biwa obeye ama U.S. abino aje o citizenship every unsimno ene nyoma amubebo bosui. 1. Obtain naturalization in a foreign state after the age of 18. Obtaining naturalization in a foreign state after the age of 18. Say after the age of 18, oko kurobiso ekoje nationality a say o US passport a ometuma jefru unsem. Akore bi below 18 bia o US a wakoye Ghana card no, the law can forgive that kid because undo that age to make that decision. Na Ghana ni bia watra 18 years no a wako ekrofo froso akoje. Oh, specified acts. Thank you very much. I think I need to get my glasses on. Specified acts. I think they were both put together. Specified acts. Now, with the 18 years, now we are Ghana, New America. Now, so we to call Ghana. I call the Ghana card. Here the sole document to show say somebody is a Ghanaian. You have gone against the United States law. They can take your citizenship from you. 2. Taking.
Hello everyone, so I have received this video a few times and I wanted to share my thoughts on it. First of all, I would like you to note that there's actually a distinction under US immigration laws between denaturalization and expatriation. Denaturalization is where the US government actually takes you to court to take away your US citizenship because you, for example, did not obtain your US citizenship properly, or you've fallen under the grounds of denaturalization, that make you a candidate for denaturalization proceedings. On the other hand, expatriation is a voluntary relinquishment of your US citizenship. And also denaturalization proceedings happen in the US, in court. Expatriation, it happens outside the US. You have to go to a US embassy or consulate near you to voluntarily relinquish your US citizenship. So those are the distinctions. Now, it's simply not true that being a Ghana card holder is a potentially expatriating act. Now, let's take a look at the US Department of State's website, which discusses Section 349 of the Immigration and Nationality Act, and that discusses potentially expatriating acts. It states, U.S. nationals are subject to loss of nationality if they perform certain specified acts voluntarily and with the intention to relinquish U.S. citizenship. Briefly stated, these acts include, number 1, obtaining naturalization in a foreign state after the age of 18. So, guys, please note that the act alone that will trigger or that will rise to the level of an expatriating act is not sufficient, right? The act has to be coupled with the intention to relinquish U.S. citizenship. The act cannot stand alone. You have to perform the act along with the intention to relinquish citizenship. And so there's actually an administrative presumption of intent to retain U.S. citizenship. Even if you perform any act that can be said to be a potentially expatriating act, the U.S. consular will then ask you, do you intend to relinquish your U.S. citizenship. If you say no, they will find that you have, retained your U.S. citizenship. You see, they want you to keep your U.S. citizenship. They love the fact that you're a U.S. citizen, right? So again, note that once you the 5th along with the 14th amendment of the U.S. Constitution states that you cannot be deprived of life, liberty, and property without due process of law. So it's simply not true that being a Ghana card holder will get you deported or can have them remove you from the U.S. Let's go back to the section INA 349, obtaining naturalization in a foreign state after the age of 18 being a potentially expatriating act. Ghanaians who are Ghana card holders are actually Ghanaians by descent. For example, their mother is a Ghanaian, and so they are also Ghanaians from birth, right? So being a Ghana card holder cannot be equated to obtaining naturalization in a foreign state after the age of 18. That is a misinterpretation of U.S. immigration law. Intino mamenka wochimu ukra Ghana card nyam password de kufi beto so in order to relinquish upe say ujai U.S. citizenship mo ese ye bibi now sanso wa adwene se o umpe U.S. citizenship ni biom intino it's just not true that just by virtue of the fact that you are a Ghana card holder and you haven't applied for dual citizenship, you can be deported. You will not be deported. In order for you to be deported as a U.S. citizen, it's more complex than that. You have to go through denaturalization proceedings, and that you'll go through court, right? And the U.S. government has to prove their case either by clear, convincing, and unequivocal evidence or beyond every reasonable doubt, depending on the circumstances surrounding how you triggered the denaturalization grounds. So I hope this clarifies a little bit. My name is AK Poku. Follow me for more.